be advised that this recorded webinar has been edited from its original format, which may have included a product demo. To set up a live demo or to request more information, please complete the form to the right. Or if you are currently not on CSE Global, there is a link to the website in the description of this video. Thank you.
And welcome to today's webinar, Critical Distinctions Between Texas and Delaware LLC Law. My name is Annie Triboletti, and I will be your moderator. Joining us today are guest speakers Byron Egan and Daniel Lewis from Jackson Walker. And with that, let's welcome Byron and Daniel.
Well, thank you, and welcome to everyone. We're talking from Dallas, Texas, where it's a warm 85 degrees, headed up to well over 100 today. So we have 5 business entity forms in both Texas and Delaware to choose from. We have the traditional corporation, we have the general partnership, we have the limited partnership, we have the limited liability partnership, and limited liability companies. But we're going to be focusing today on LLCs in Texas and in Delaware. We will discuss other entities for comparison, and because courts in LLC cases may refer to precedent in those other areas for precedent regarding LLCs. In the slides that you're going to be seeing, there'll be references to EGAN on entities and various sections and pages. Those are references to EGAN on entities, my book, Corporations, Partnerships, and Limited Liability Companies in Texas, 4th edition, 2023, which is available from CSC in LexisNexis with a link below. I said we're going to be focusing on LLCs, and the reason is that we're forming them in Texas at a 15.2 to 1 ratio. Repeat, we're forming over 15 LLCs for every corporation that we're forming in Texas, and the other entities are way down the list. So the result of that is, although we've had a corporation for almost 2 centuries, we now have about 5 times as many LLCs as we do corporations in Texas. And in Delaware, the ratio is a little bit different. It's about 3.9% excess in formations in 22 over corporations, and they now have substantially more, about 3.8% more LLCs in Delaware, even though they've had them for 2 centuries. So the focus today is going to be on LLCs, but in Texas we have a new development that affects LLCs and other entities in Texas. Currently, disputes regarding LLCs and other entities are tried in Texas district courts, generally jurisdiction courts with elected judges, for which trial by jury is generally and typically available. Appeals go to an intermediate court of appeals and ultimately to the Texas Supreme Court. But that is changing. After 10 years of efforts, in 2023, the legislature passed a bill to create specialized business courts in Texas. These are analogous to the Delaware Court of Chancery, but a bit different. This is House Bill 19 that we'll be referring to. This bill will take effect on September 1 of 23, but we're not going to have trials for another year, and even then only in the 5 major metropolitan areas: Austin, Dallas, Fort Worth, Houston, and San Antonio, and surrounding counties. But it takes a year basically after you go effective to begin to get judges appointed, to have rules adopted by the Supreme Court, and so on. Appeals from the business courts are going to be heard by a newly created Court of Appeals and ultimately to the Supreme Court. With a new court system with appointed judges, we're going to have likely challenges to the constitutionality of the legislation. And the legislation provides that there's a direct appeal to the Texas Supreme Court. It has original jurisdiction over any constitutional challenge. So if there is one, that's how it's going to play out. The hot button issue has been, are the judges going to be elected as they are currently, or are they going to be appointed judges? And what the legislature decided is we're going to have business court judges appointed by the governor with the advice and consent of the Texas Senate. And they're going to be appointed to 2-year terms and may be reappointed at the end of that term. That's basically a constitutional requirement. The judges, they're seeking to have experienced in business disputes and transactions to be the judges. So they'll have to be licensed attorneys. They will have to have at least 10 years of experience in complex commercial disputes and transactions, must have been a resident of the county within which the division of the court is appointed for at least 5 years. So the idea is to give you both experience and local judges. The bill contemplates that the Supreme Court will be adopting procedural rules and that the courts will be providing written opinions that will have precedential value and serve to enhance the commercial certainty. Currently, district courts typically do not write legal opinions that are published with respect to their decisions. So there is somewhat of an uncertainty as to what Texas law is until you get appeals. And the courts of appeal, both the civil appeals and the Supreme Court, will currently be having written opinions, and now the business courts will also. The business court cases may be tried to a jury when required by the Constitution. The contemplation is that most cases will not have jury trials, but it's a constitutional right. We'll see how it plays out. The jurisdiction has been a difficulty in the legislature. Who's going to have, what kind of cases are going to go to the business courts? And what the legislature ultimately decided is that first you want significant disputes. So the courts will have jurisdiction over cases where the amount of controversy exceeds $5 million, and those will be derivative proceedings, breach of fiduciary duty claims, matter of corporate governance, piercing the corporate veil claims, securities claims, and the like. Then there's another level where the amount of controversy needs to exceed 10 million, and that's very complicated. The bill goes for a couple of pages in detailing the jurisdiction, but the essence of it is that there'll be financial loan agreement transactions, except in the case of banks or savings and loans or the like. And then there'll be another class where purchase and sale agreements, if the parties have agreed initially or subsequently to business court jurisdiction. So that's going to be an issue for us sit-down lawyers. Are you going to provide in your agreements for a choice of venue? And if so, are you going to provide for Texas law to govern and for the cases to go to the business court, assuming they meet the other jurisdictional requirements? There's an exception that if it's a publicly traded company or the case involves injunctive or declaratory relief, then there's no amount of controversy required. Delaware is similar, but quite a bit different. Disputes in Delaware regarding LLCs are typically tried in the Delaware Court of Chancery, which is an equity court of limited jurisdiction with appointed judges, and they do not have any jury trials. Appeals for the Chancery Court go directly to the Supreme Court. So this is a change in Texas law that you'll be seeing unfold. The first cases will be a year out, but there'll be a lot of planning in between. Texas has originally had its entities in separate statutes like Delaware does today, with one for corporations, one for partnerships, one for LLCs. But in 2003, the Texas legislature decided that all business entities, including nonprofit corporations, ought to be in one code, one business organization's code, one statute book. And so any new entities formed after January 1, 2006 would be under the new code. And after 2010, all Texas entities are going to be governed by the code. It's the TBOC codified source law, and it's been amended in every legislative session since then, including the one ended May 29. And that's in response to cases in other states' statutory changes. We have a bar committee that develops laws, watches what's going on elsewhere and in our courts, and recommends changes. And we have a Texas Business Law Foundation, which hires a lobbyist to get the stuff filed and passed. The organization of the code it has a hub and spoke approach. And the hub is basically in chapters 1 and 2 entitled 1. And that'll deal with definitions. It'll deal with the formation of entities. It'll deal with mergers of entities. It'll deal with indemnification and other things that are common to all forms of entity. There'll be, of course, differences between the forms, but the idea is to have a hub with the common provisions and then the spoke in separate provisions. So we'll have a chapter for corporations, one for LLCs, one for partnerships, etc. The Delaware statutes are like Texas used to be, a separate statute for each kind of entity, and the Delaware LLC laws are in the Delaware Limited Liability Company Act. So, Daniel, these entities are taxed, and that's going to be important in your choice of entity. You want to tell us a little about it?
Absolutely. Thanks, Byron, and thank you, everyone, for attending. So we're going to pick up now with an aspect of entity choice that is always at the top of people's minds, which is tax. And obviously, people tend to want to minimize their taxes when they can. So this is something to definitely ask your client about and think through as you make those decisions. So jumping right in, we've got a few stats here on corporate taxes, and I think that the key difference to remember between corporations and LLCs, both in Delaware and Texas, is pass-through treatment versus being taxed at the entity level. Corporations are going to go ahead and pay tax at the entity level, whereas an LLC will pass through to its members. And I guess I just kind of jumped the gun and got ahead of myself a little bit, so I won't belabor the point here. In Texas, you also need to be cognizant of your margin taxes. Those are going to be due in May every year. And as a general rule, this is going to apply to all business entities, with a couple exceptions we've listed for y'all here. This is basically your gross receipts after some deductions for some of these items bulleted here, your W-2 cost of goods sold, 30% of gross receipts, or just $1 million. And although you might think that looks, sounds, and acts a lot like an income tax, the Supreme Court of Texas would disagree with you. based on a 2012 case, the All Cat Claim Services LP case. And so I won't get into all the nitty-gritty since you can read it for yourself here, as well as in EGAN on Entities, but ultimately they're going to be looking at paying a portion that has to do with your Texas gross receipts versus U.S. gross receipts. So we've discussed some of the aspects of Texas entity taxation. Now let's take a look at Delaware here. The corporate tax rate is a little bit higher than a lot of states. And we know that Texas actually does not have a corporate income tax, although, as we just discussed, there is that margin tax. But the Delaware general corporate law is going to have some generous exemptions here. And so it very well may be that you don't end up paying a great deal in the way of Delaware corporate income tax. If you maintain your statutory corporate office, or if your activities with the state are confined to the maintenance or management of your intangible investments, which captures quite a few Delaware entities, so that's something to consider. But now let's turn to the entities we're more focused on today, LLCs. Delaware state income tax does not apply at the entity level to an LLC, unless you want to, for various reasons, opt in. And I'm not a tax expert, so I won't pretend to know what those reasons might be, but suffice it to say, it's always good to consult with a tax expert. It is good to bear in mind that LLC members might be taxed differently based on whether they are a resident or a non-resident, and based on where the income is sourced or attributable to. So let's take a moment here and shift gears just a little bit and discuss some of the basic vocabulary that comes into play when you're dealing with LLCs in Texas. So whereas in a corporation you've got shareholders or stockholders, in a limited liability company you've got members or the owners. They're analogous to shareholders. You could have a member-managed LLC. We do see that a fair amount. Or you might have a manager-managed LLC. Managers are essentially the same thing as the directors on a corporation's board. Again, those managers might be the members. They might not be the members. It's up to you to decide. And so that's something to discuss and spell out in your governing documents. Now let's take a quick look at a little bit of LLC vocabulary that's pertinent to Delaware. If you're an LLC in Delaware, the Delaware Limited Liability Company Act will govern you. Just as in Texas, the LLC's owners are members and are, again, analogous to the stockholders or shareholders of a corporation. So the first governing and kind of formative document that you would need to get your LLC up and off the ground is your certificate of formation. In Texas, you're going to file that with the Texas Secretary of State, and it's also going to come with a little filing fee. You can find, just a quick Google search will do the trick, you can find a template certificate of formation, and the Texas Secretary of State even provides this nice PDF where you can just fill and sign. But however you go about it, you want to make sure your certificate of formation contains these items we've listed out in the second bullet point here. So what is the entity's name? You got to state that it's an LLC and so on and so forth. I won't hash out all of these. Again, feel free to access the slide deck afterwards or check this out more closely in EGAN on Entities. But the gist of it is you just want the Secretary of State to know some basic info about you and how they can contact you, and just kind of be aware of what companies are out there and existing in the state. One final point to flag here. If you change managers, that doesn't necessarily require you to amend your certificate of formation. You may want to anyway, and it can just kind of help keep everything clean, but that's just something worth noting. The certificate of formation, like we said, is going to get filed with the Secretary of State. Generally, it's going to be effective when it's filed, but you could also, in your certificate, say that you want to delay effectiveness for whatever reason. You might also form your LLC under a plan of merger or conversion, in which case you'll need a separate certificate of formation that's filed with the certificate of conversion or merger. And generally, a Texas LLC can conduct any lawful business. It's got kind of broad powers and capabilities, but you could also choose to restrict what your company is going to do by stating otherwise. I think the key thing to bear in mind when you're going to name your LLC is you need to have something like LLC or Limited Liability Company in the name. It's obviously a little confusing to everyone if you go around naming things ABC Inc., but it's not a corporation, it's actually an LLC, and so that's what drives that rule. Let's see, and I'll leave it to folks to dive into a couple of these other finer points in the book if they so choose. Now let's turn to where most of the meat and potatoes are going to be in a Texas LLC's governance. It's going to be in its company agreements, or a limited liability company agreement, as you might otherwise hear these things called. In Texas, we tend to call them company agreements. This is going to really spell out how things work for this entity. Who is going to manage it? How are we going to govern its securities, its membership interests? There's a little bit of, there can be some interesting things that come up when you don't actually write out your company agreement. As a little bit of an aside, I did some research into this a little bit last fall, where we had some doctors and medical investors who had an LLC, but they never actually wrote out a company agreement, and things went south, and it suddenly became rather difficult to discern, well, what were we going to do? How was this going to be governed? How was it going to be managed? We don't know any of these things because no one wrote it out. That doesn't necessarily mean that it can't be oral or implied, but it does get messy, and it's probably going to help guide everyone if you just write it out. And for what it's worth, if you just hopped onto Westlaw, you could find a nice little practical law form for Texas that gives you a really good starting point. Other things you might see in a company agreement, besides management or officers and whatnot, you'll probably also want to discuss capital accounts and how gains and losses are going to be allocated, how distributions will work. People are usually going to be very interested in that, in the distribution mechanics. That's hopefully how you're going to get paid in all of this. And a few other things to point out. You can, in fact, have a single member LLC that, you might think, well, why would you really need a company agreement if there's just one person involved? There could be a number of reasons. Maybe this is going to be a wholly owned subsidiary, but it might get moved around in your corporate structure. It might get sold to someone else, in which case, they're kind of stepping into these shoes here. So just because there's only one member also doesn't necessarily mean that you want to bypass this step, it's still probably going to be a good idea to have that company agreement there, just to, again, spell out how everything's going to work. Now let's turn to Delaware a little bit. Just as in Texas, you're going to form your limited liability company with a certificate of formation. It's going to have that same general list of basic information, which again is really just aimed at helping the Secretary of State know what entities exist in the state, how to get in touch with them, and just have that basic information. In Delaware, we also see limited liability company agreements. They don't tend to get called company agreements the way they do here in Texas. It'll usually just be called a limited liability company agreement, and often will get abbreviated as LLCA. Again, you're going to see pretty similar things to Texas. You're going to want to spell out management here. Is it member managed? Is it manager managed? How many managers are there? Are there officers? Things like that. This is also going to discuss distributions, allocations, capital accounts, and how money is going to move and flow through this entity. So looking a little bit more closely at management here, and flipping back to Texas, if your LLC is manager managed, again, that just means managers are going to oversee it. They might be members as well as managers, but they might not be. This is basically just going to go ahead and make them separate and distinct, which could be helpful if you want to swap out managers, if members might buy or sell their membership interests and things of that nature. Your managers don't have to be natural persons. They could be other entities. We see that all the time. Again, it's kind of up to you. Limited liability companies are sort of a business sandbox. You can do most anything you want with them, which is part of their beauty, is their flexibility. You probably also want to take some time in your company agreement to state, if you can bind this LLC in contracts and otherwise. You don't want some member going rogue and starting to sign contracts and get you locked into leases and other things without the other members being on board with that. So that's something you would do well to spell out here. Again, you should probably also take a little bit of time and just think about what's the process for choosing your managers. How long are managers going to be managers? If we don't like what they're doing, can we remove them? One of the first things I did with Byron when I came to our firm was we had a client who used to be a manager of the company and was getting a little dissatisfied and frustrated by the current management, and he was trying to figure out how to remove them. And we ultimately had to think of some creative ways, because the company agreement itself would not actually say how long the managers were going to be managers or how you can remove them, things like that. So it's also worth just thinking through that process and making sure everyone knows how that's going to work if things maybe go a little bit south down the road. An LLC can have certain agents, and this is, again, something you can look into in a little bit more depth in EGAN on Entities. But I think just to keep things moving along, that can conclude our management portion. And Byron, I'll turn it back over to you for fiduciary duties.
Well, fiduciary duties are certainly a hot button issue. And of course, the question is, what is a fiduciary duty and who owes it? In a corporation, a director owes the duty to be careful in what is being done, to be informed when the director makes a decision. And one of the challenges in the courthouse is, were the directors adequately informed? Another question is the director acting in the best interest of the corporation, or is the director acting in the director's personal interest? That's the duty of loyalty. And then we have the duty of obedience, which is basically to follow the law and the governing documents. That's a corporation. The TBOC, by the way, that is the Texas Business Organizations Code. It does not specifically address whether managers or members have fiduciary or other duties. It doesn't even attempt to define it, but it implies that they may exist under various statutory provisions that permit a company agreement to expand or restrict them, and may even limit or eliminate the duties or the liabilities for breaching them. So that's a critical point of what you're going to put into your company agreement. And if you're silent, then they're going to be the traditional corporate fiduciary duties. In a manager managed. So we talked about management. In an LLC, you can have managers who are the equivalent of directors who manage the business and affairs of the company and elect officers or select officers, because this is very much a matter of contract. But it could be managed. It could be managed by the members. You do essentially the same thing in a corporation, but the managers, be the elected managers or be it the members that are managing the business, are going to be generally assumed to have fiduciary duties managed and measured by reference to the corporate duties, as if the company agreement doesn't say otherwise. But that gets to our duties as to drafting as lawyers. So by analogy to corporate directors, managers are going to have duties of obedience, care, and loyalty, and would have the business judgment rule benefit. So the business judgment rule in the corporate context is that courts will defer to the business judgment of directors when they make decisions. It's not the business of the court to second guess the business judgment of a director. But then, of course, courts can't resist doing it. So particularly in Delaware, they're going to grade whether the directors or the managers got enough information to make an informed decision. Texas tends not to second guess managers or directors. The courts sort of say a manager is making the decisions for the business, and that includes how much information that manager should have. So that's the difference in Texas and Delaware law. The fiduciary duties are generally owed to all of the members of the LLC, just like corporate fiduciary duty is owed to all of the corporation's shareholders. Now, you can write in your LLC documents to whom the duties are owed. But that presupposes that there are going to be no duties. So as we said, the presumption is that there are fiduciary duties like corporate fiduciary duties, but the TBOC in these three sections allows a company agreement to expand, restrict, or waive duties, any duties, including fiduciary duties and associated liabilities of members, managers, officers, and other persons to the LLC or to its members or managers. So that's contractarian approach to it. Delaware essentially follows the same approach. To the extent that any and all fiduciary duties are waived, there would be no fiduciary duty to breach, and thus there would be no liability for breach of fiduciary duty. TBOC section 7.01 allows for the limitation or elimination of liability. So the focus is on liability to the LLC or corporation or other entity for breach of fiduciary or other duties. In the case of a manager managed LLC, of those members with management responsibilities, with a big exception for a breach of the duty of loyalty or acts in bad faith or where the person is receiving an improper personal benefit, or where there's a statutory liability like for breach of securities laws. So there's that 7.01 applies to corporations and partnerships, etc., whereas 101.052, etc., apply only to LLCs. So that's a big difference. A company agreement provision restricting or eliminating fiduciary duties and limiting or limiting liabilities as permitted could read as follows. And I'm not going to read the whole thing to you, but you get the idea. It's the agreement's not intended to and doesn't create or impose any fiduciary or other duty on any member or manager. Furthermore, the members and managers, to the fullest extent permitted by applicable law, which is defined to be the TBOC, allow the elimination of duties or restriction, then we agree that the obligation are contractual in nature and are only as expressly set forth. So we're basically waiving all other duties. And then we say that to the extent there is a duty, it's not fiduciary in nature. A breach of the fiduciary duty is a tort, whereas a breach for which there are remedies, and that includes punitive damages. But a breach of contract is a breach of a contract, and that's usually limited to actual damages. There are obviously exceptions to all of these things. So then you get into, well, wait a minute, if you have eliminated all of the duties except as set forth in this agreement, then what are the duties? And that gets to be dicey. You want to limit things. So what about competition with the entity? You certainly don't want to authorize somebody to steal money from the entity. You want people to be using the assets of the company for the benefit of the company, and so on. So those are things that you need to spell out in your company agreement if you're eliminating fiduciary duties. And then what about other business relationships? Business opportunities, are they going to be waived? If you've got a private equity investor that's making lots of investments in lots of portfolio companies, it may want to restrict what the managers of this particular company can do, but have absolute leeway to do whatever it wants to do with its other companies. So these are highly negotiated provisions. And sometimes your investors may not agree to the limitations. And by the way, as lawyers, we've got to think very carefully, is elimination or waiver of fiduciary duties right in this situation? That's a question, and we're going to have to answer it for our clients. And if they don't ask us, we ought to be discussing it with them. Now, in Delaware, there is a common law duty of good faith and fair dealing. And I've had dialogues with the Supreme Court justices in Delaware, and they say, I say that you've eliminated fiduciary duties, but you're, in your opinions, basically using good faith and fair dealing is a way to morph into fiduciary duties, which you've otherwise eliminated. And they, of course, disagree with me. But in Texas, does not exist in all relationships. Where there's a special relationship between the parties, as in an LLC, then there may be an implied duty of good faith and fair dealing. So that's a case law thing that you just need to think about. There are no reported decisions about good faith and fair dealing in the LLC context. But it's likely that just like fiduciary duties, in the right case, of course, it's going to find them. TBOC 101-601 provides for the principle of freedom of contract to be applicable to LLCs, which allows the elimination of fiduciary duties, as we talked about. 101-255 is based on the corporate statute, which allows a corporation for transactions between the managers and members of an LLC and other entities to have a financial interest in the transaction, and it will not be void, but for it to be enforceable, the material facts have to be disclosed to the people that are approving it or known, and so on and so forth. In a joint venture, your duty of a manager to all members could be an issue, since the joint venture very often has the management determined by a particular party who they expect to be operating in their benefit. So it's, again, one of the things you need to deal with. In Delaware, they went through a long period of time where it was uncertain about fiduciary duties, where they can be eliminated. The Limited Liability Company Act does not codify them, but provides that they may be eliminated. And another statute says that unless modified, common law fiduciary duties apply to LLCs in Delaware. Then again, Delaware is a contractarian state and will allow waivers of fiduciary duties. I've got a sample provision eliminating fiduciary duties that basically says that we're waiving and eliminating all fiduciary duties, but we're not eliminating the contractual covenant of good faith and fair dealing, which is non-waivable under Delaware law. Obviously, as in Texas, there's going to be serious negotiation as to how that's going to work. In Delaware, if you're going to limit fiduciary duties, you've got to be very careful that you're very express as to what you're doing. In at least one situation, the chancellor said that an agreement's coyness can make it unenforceable. And so if you're not precise in what you're doing, you may, by limiting the liability, create a concept that, except as you expressly set forth, all of the fiduciary duties are in there. So you got to be very, very careful. Caremark is a concept in Delaware that's pretty serious, because what that takes is what looks like a duty of care obligation and violation. It makes it a duty of loyalty violation. So in Delaware, they hold, this is the Caremark doctrine, can be violated their fiduciary duty of loyalty when they fail to act in the face of a known duty to act. And for Texas folks, they'll remember Bluebell Creameries. That's the Delaware Supreme Court opinion in Marchand versus Barnhill, where Bluebell was a subchapter S Delaware corporation headquartered in Bremerton, Texas, and it made ice cream that was tainted with listeria in one instance, and 8 people were sickened and 3 died. So that produced a recall of the ice cream, a suspension of operations, a laying off of a third of the workforce, and to survive, they had to enter into a highly dilutive transaction with a private equity investor. Needless to say, there's a lawsuit that gets filed, and the derivative action alleging the directors breached their fiduciary duties. The Delaware Supreme Court held that while Bluebell had food and safety programs in place and nominally complied with the FDA regulations, and the vice chancellor had found that the board got information that they knew that management had these programs in effect, but the directors were not hands-on involved. So the court writes, the complaint alleges that Bluebell's board had no committee overseeing food safety, no full board level process to address food safety issues, and the board had no process for safety reports and developments to be reported to it. So the bottom line is directors had a duty of loyalty to make a good faith effort to have a system for monitoring the compliance risks, and that the failure to do that was a failure to satisfy mission critical compliance obligation, and the directors were liable. So that suggests that board of directors of corporations should have special committees tasked with monitoring corporate risks and so on and so forth. After Marchant, there have been a number of Caremark kind of cases in Delaware, and it's going to surface more and more in Delaware disputes. Caremark has not been adopted by the Texas courts, and they would treat duty of, well, what is a Caremark duty of loyalty claim, they would treat as a duty of care claim. And under Gerhardt and Steed versus Weber, there would be a strong Texas deference in the business judgment of the directors. So the idea is courts are not going to second guess the business judgment of directors. Joint ventures, Daniel, you want to take up and talk about those?
Absolutely. Okay, so a joint venture, or you might hear it sometimes just referred to as a JV in corporate slang, is where two, I mean, it could be more than two, but generally two entities are going to team up and come together to do something. It could be in a real estate context, maybe it's to buy an airplane, it could be all sorts of things. And generally, an LLC is going to be the best way to formally, I guess, implement this decision to team up. And so if you want some more details on how things might go a little bit wrong if you just start throwing around the term joint venture but you don't really mean it, you can read up on this Dernick Resources Inc. case in EGAN on Entities. Given our time, I'm going to go ahead and move on though. Here is one case that's worth flagging while we're discussing JVs though. This is Energy Transfer Partners. It's a decently famous case here in Texas now. So what we had was ETP, or Energy Transfer Partners, and Enterprise, kind of similar names, sorry for the confusion there, entered into these agreements. And they said, look, we're not going to be obligated to do anything until we've executed definitive joint venture agreement, or sometimes you'll hear it called the JVA. That's really just, in Texas, your company agreement, or in Delaware, your LLCA. And we need the JVA to be approved by our boards of directors. So they never actually did sign up their definitive JVA, but they went ahead, they were spending time and money on the projects. Things seemed like they were going well. They were kind of holding themselves out to the public as being a joint venture. They'd market this pipeline to potential customers, still kind of holding themselves out as a joint venture, but their marketing efforts did not get them where they wanted to be. And so, as is always the case when we're looking at a court case, things went south. And so Enterprise said, all right, look, we're terminating, we're not going to participate anymore, and we're going to go and make an agreement with another large pipeline company. Well, ETP did not like that. They sued Enterprise. They said, look, we had this agreement. You breached it. And what's more, you had fiduciary duties. So, all they really had, though, were these preliminary agreements. No one actually signed it and was bound to it, you might think. And so the jury found that, hey, even though you didn't sign this, your ensuing conduct did make this a Texas general partnership. And so, yeah, you did breach your fiduciary duty of loyalty. And so a big old, basically $500 million judgment was entered in favor of ETP. The Supreme Court of Texas held that actually, no partnership was created. We had an NDA and we had a letter of intent, and those things spelled out that no party is bound to proceed with the transaction unless and until a definitive JVA is executed. They never actually did execute a JVA, and so no, there's no actual duties owed according to the Supreme Court of Texas. So I'd say the punchline here is this is a good cautionary tale about, number one, if you've been negotiating definitive deal documents, make sure those get signed before you actually go out there and start running the joint venture that you're going to run. Otherwise, if things go badly, your counterpart might decide they want to drag you into court and sue you for a lot of money. And it also illustrates that actually in Texas, we're not necessarily going to imply or find that your course of dealings imply that there was a partnership here. But I want to also put the little caveat here that their NDA and their letter of intent that they did sign had expressly talked about, look, if we don't actually sign definitive deal documents, then we're not bound. So what would happen if you didn't have the signed NDA and LOI that said that? That's a question for another day. Suffice it to say, I would not risk it. I would make sure you sign everything. Okay, so having gone through that, let's look a little bit at business combinations. So LLCs can merge with one or more other LLCs or other entities, like corporations, partnerships, and whatnot. This is mostly just going to depend on what your constituent documents, your company agreement, your certificate of formation, and whatnot allow. Also, Texas LLC can merge with, or it can turn into, a Delaware LLC. I did that for a number of entities earlier this year, as well as the other direction, going Delaware to Texas. Not an especially complicated process, and the Texas Secretary of State and Delaware Secretary of State very helpfully have a lot of fill and sign PDF forms that will help guide you through that. But it is a bit of an endeavor. You're going to want to update your governing documents. You don't want to have a Texas LLC's company agreement talk about how it's a Texas entity and it's going to be governed by Texas law and whatnot. Turn it into a Delaware company and then not update that. That can create some hiccups that you would probably prefer to avoid. Given where we are in time, I think I'll just suffice it to say your merger is going to be governed by a written plan of merger. It's going to need to be filed with the Secretary of State, and you can look at EGAN on Entities to get some more details on that. You're going to want to make sure that you comply with your governing documents as you go about a merger. Generally, the default is that the majority of the LLC's members by membership interests need to approve these sorts of things. Although, again, check your governing documents. Maybe you have a company agreement that requires a supermajority for something like this, which is not uncommon. But point being, you need to make sure everyone's on board. Otherwise, you might try to go through with the merger and you could find yourself getting dragged into court by disgruntled members who you just kind of railroaded into doing this. Let's see, and then another thing to flag here is your company agreement's typically going to have some restrictions on just assigning your membership interests. You don't want to just start handing out your membership interests willy-nilly. That could get you in trouble with the SEC or the IRS, or because Texas franchise tax problems and all sorts of things. So again, look to your company agreement. Make sure you read it carefully and know what it says, and you comply with those restrictions on assignment. Byron, I'll defer to you here, but I know we're pretty short on time at this point.
Daniel, you're just talking about business combinations, and Texas, since 1989, has had the concept of a divisive merger. We thought, well, you could put entities together, so why not be able to divide them by a merger? So we defined merger to include the division of an entity into two or more new domestic entities or organizations. You have to have a plan of merger that provides how that's going to happen, how you're going to divide and allocate the property and the assets among the entities. But if you have it expressly done, then you're basically when you file your secretary with your okay, a divisive merger is done pursuant to a plan of merger that specifies how the assets are allocated and how the liabilities are allocated. And under our statute, if you are expressed as to what you're doing, then the court will respect that allocation. So you can put assets in good company and bad company, and liabilities the same way, and minimize some of your liabilities. But there are a couple of exceptions. And the big one is you can't impair the rights of existing creditors. So if somebody's got a security interest, you can't violate that security interest. If you've got a transfer, it may be a fraudulent transfer if you don't have adequate assets being left in both entities to satisfy creditors. So that's a short summary of what you can do for a divisive merger. That's a very complicated situation. Delaware has a similar concept. They call it a division, while we allowed it for corporations, partnerships, and limited liability companies. So any kind of entity can do it, do divisive merger. In fact, we can even do divisive mergers with other states' entities. We've said that a Texas entity could effect a divisive merger with another state if the laws of that state permit it. Or we could merge with a billy goat if the laws governing the billy goat so permitted it.